So now is the time for us to begin the next segment of this symposium, which is a debate on the subject of, is the FISA Court, or if you prefer, the FISA Tribunal, too secret? My name is Charles Kennedy, and I'm a Justice of the Florida Supreme Court, and I'm delighted to be here to moderate this debate today. The two debaters who will be conducting the debate are Alex Abdo of the ACLU and Professor Gregory McNeal of the Pepperdine University School of Law. Now, both of the debaters have asked that I not give a more extensive introduction of them. You can look it up online if you have not already done so. The format for this debate will be relaxed and informal. We are going to start off with the general question that is the topic of the debate, and then we'll have some follow-up questions. But we'll conclude the debate with 3-minute statements by each of the debaters. So they'll each get in their final word. And then their final statements will be followed by 15 minutes of questions. So, we're all glad to be here. I'm very pleased to have this privilege of moderating, and we will now begin the debate with the question, the general question, is the FISA Court too secret? And we'll begin with Alex.
Thank you so much, Justice Kennedy. And we've decided, just so you know, to stay in our seats to encourage a more informal exchange so we can debate each other more back and forth rather than orate it at length and maybe not be as responsive to each other. So I just want to start off by saying it's a delight to be here. This is my first time to be at a Federalist Society event, and when I was telling a close friend in New York that I was coming here for the event, this friend who happened to be a big D Democrat said, "You're really going into the hornet's nest." And I don't know whether that's true, but if it is, this is certainly the friendliest and smartest hornet's nest I've ever been in. So I'm very delighted to be here, and I'm excited to be on this panel with Greg and Justice Kennedy. So let me start out by addressing this question of whether the FISC or the FISA Court is too secret. And I think the answer is yes. That probably won't surprise you to hear me say that. But I want to go back to 1978, which is when the FISC was first created. Because for the first about quarter century of the FISC's existence, what the court did was largely unobjectionable if you think about it from a privacy perspective or from the perspective of secrecy. It largely heard individual applications from the government to target specific individuals for surveillance. And the issues presented before the FISC in those applications, as Professor Barnett mentioned in the last panel, was whether the individual was an agent of a foreign power. In other words, the FISC was engaging in a pretty fact-heavy analysis and issuing a decision on the facts of whether the person the government wanted to target could lawfully be targeted. That has dramatically changed. The role of the FISC is no longer only to hear those types of fact-heavy questions and to issue fact-heavy determinations, but to oversee and preside over broad programs of surveillance. The FISC now is involved in answering some of the most important constitutional questions of the day, whether the bulk collection of information is secret, whether truly every one of our international communications are fair game for surveillance, which is, if you believe the reporting, the state of affairs now, and what will likely be even more significant constitutional questions in the future. And so the question, I think, for me is whether the answers to those questions should be litigated in secret on the basis of one-sided presentations to a secretive tribunal, and for which the answer should remain secret. And I think the answer to that question is quite clearly no. I think there are real costs to secrecy to that extent. Secrecy on those fundamental questions that go to what privacy means in a digital age, can be corrosive to democratic self-government. They prevent the people, who are the ultimate check on government authority, from exercising meaningful oversight over their elected representatives and from carefully scrutinizing the decisions of their unelected representatives in court. I think a related cost is that it undermines trust in government for there to develop a great gap between public understanding of what the government is doing and the government's actual exercise of authority. And I think that will likely be one of the biggest takeaways, I hope, for the NSA of the disclosures over the last year, is that if the NSA wants to maintain and continue to do the very important job that it does, it's essential that it maintain public trust. And I think a way of doing that is to narrow the gap between the authorities that the NSA exercises and the public's, at the very least, broad understanding of those authorities. And the final cost, I think, to secrecy of this nature is that it affects the quality of judicial decision-making. And this is not to suggest that the FISC, the judges of the FISC are acting in anything but good faith. I think it's hard to read their opinions and think that they're not at least trying to do the right job. But they're trying to do it in an extraordinarily difficult circumstance on the basis of one-sided presentations in secret without the opportunity for their opinions to be part of the judicial conversation that is so important to our system of common law. You know, a lot of people, and you heard this yesterday, particularly on the panel from Rachel Brand, like to focus on the fact that 15 judges of the FISC have approved the telephony metadata program, the phone records program under Section 215 of the Patriot Act. But what we didn't hear, I don't think, anyway, is that there wasn't an opinion from the FISC actually examining the legality of that program until August 2013. That is a few months after the Snowden disclosures. For the first 7 years of that program's operation, there was not a single legal analysis performed by the FISC to analyze whether the program was lawful. So, you know, no matter what you think of secretive legal processes, I think you should be troubled by the fact that the incentives are not necessarily properly placed in that type of system. So it's not surprising then that in that system the program was ratified. You know, what is surprising perhaps is some of the most important arguments against the program were not considered until August 2013. And then even when they were considered in August 2013, some of the key components of the argument were not considered. For example, whether Jones, the Supreme Court GPS case, changes the analysis. So those, I think, are the very real costs of excessive secrecy. And of course, you know, there are costs to transparency too, to excessive transparency when it comes to the operations of the intelligence agencies. And so I think it's important to consider those as well. But the fundamental problems, I think, with the NSA's presentation of those costs, and particularly listening to Stuart Baker in the last panel, is that the consideration of that cost can't exist in a vacuum. You have to also consider the cost to a democracy of allowing so much information to remain secret. You could have argued in 1978 that when the Foreign Intelligence Surveillance Act was passed, that the statute itself should have remained secret. You might have argued that the KGB would have had less information about how the NSA goes about its business if the procedures for the NSA to wiretap inside the United States remained secret. But that level of secrecy is anathema to a democracy, and it wasn't even considered a proper question back in the 70s. And yet, nonetheless, today we have programs that operate on a far greater scale, being kept entirely secret from the public. And I think that's because the intelligence agencies do not give adequate consideration to the question of whether these programs are ones that the public should vote on. Not necessarily at the booths, but through their vocal participation in the debate that we're now having. So I'll leave it there for now. I know I've talked for probably more than I should have to begin with, but that, I think, is the framing of the debate to my mind, and a suggestion for an answer.
So we wanted to do a conversation style because Alex and I were on a panel in Chicago together, and we realized that there were many points of agreement between us. And so what we thought would be best would be to start with sort of those points of agreement and then start to try and tease out the nuanced differences between us. And we didn't think that could be done in a way, in a really effective way, without sort of sitting where he could secretly kick me when I was going on too long. And so I was kicking him the whole time. You guys just missed it. It's a pleasure to be here. It was not too long ago that I was seated where you are as a former Federal Society chapter president. It's always great to be here and be able to speak to our students and our future leaders in law and in government. So this question is the FISC too secret? Yes, in part. Right? And my in part really doesn't go to the call of the question, but goes more to who's to blame for the issues that we have with regard to FISA secrecy. And I think that Ron Wyden, Senator Wyden, had actually a pretty apt quote where he said there are lines to be drawn between protecting classified operations and making sure that the laws themselves are public. And so I think that actually tees up the debate pretty well for us. There should not be greater transparency on the FISC with regard to operations. However, the idea that law can be made in secret by unelected judges with life tenure, to me, sort of goes to this thing that every time I went to a Federalist Society conference, someone was saying something about unelected judges making laws on their own. And so I think that's the biggest point of agreement between Alex and I, that laws should not be interpreted in secret without an opportunity for the public to know that the law that is on the books differs substantially from the law that's actually being implemented. And that's why we see such controversy over the 215 program. I think every national security law expert that I know and every crim pro expert that I know looking at Section 215 did not believe that it had the ability to extend to the collection of all metadata, that bulk collection program. I think that everyone who has since looked at it realizes that that is a big disconnect from what the statute itself says, the idea of defining relevance in such a broad way. And so if we're going to have democratic accountability, we need to know when a court makes a determination as a matter of statutory interpretation that doesn't comport with the law as it's written. And so this is where I think that our focus in our discussions is really off. I think that our heavy focus on the NSA is doing blank. If you, for the rest of the day, if you have a statement that begins with the NSA is doing blank, you're sort of looking at the symptom but not the underlying disease. And the underlying disease to me is a Congress that wants things to operate the way that they do. Congress wants the FISC. Why does Congress want the FISC? Because it allows them to push accountability off to someone else. If you're responsible for conducting oversight of secret operations, you're on the line if the operations go too far one way or another. But if instead you have the Foreign Intelligence Surveillance Court that's supposed to be doing some sort of oversight of operations, you can sort of walk out and say, you know, I'm glad that there's a court that's doing this and they've sort of taken care of it. When that court gets it wrong, right? They tighten the strings too much, and we can't conduct surveillance. Everybody who's an elected official can say, well, you know, it's not our fault. The court wouldn't let us do more. And when the court goes too far, rarely will we hear about it, all right, when the court authorizes too much. And even if we do hear about it, the elected official can say, this seems to be the kind of thing that's in the interests of security, and oh, by the way, the court signed off on it. So in both ways, it allows us to dodge political accountability. And so that goes to the democratic accountability problem. And so really it's a mixed problem here. The FISC is not transparent with us with regard to its decisions, but also the Congress is not transparent, specifically the intelligence committees, with regard to problems that come up along the way with the FISC. So another example would be that prior to the Snowden leaks, there were individuals on the Senate Intelligence Committee, there were senators who wanted to change aspects of the 215 program and wanted to change aspects of FISA, and they were not even able to discuss the laws that they wanted to change and how the votes went in conference. Not because the information was classified, but because under Senate rules, the Senate Intelligence Committee has its own rules like every other committee. You could deem something committee, I'm trying to remember the term. It's not committee secret, but it's a matter for the committee. And that essentially, it's Rule 9.3. And that rule then requires you to refer to Rule 9.2, which says that any committee matters that are deemed committee confidential should be treated in the same fashion as classified information. And so this is deep in the weeds, but it's pretty important if you're sort of the type of conservative that I was before really digging into this, which is a national security conservative who thinks, you know what, we've got democratic checks that are in place and the system's working just fine. But then when you start to peel back the layers, you start to realize that the system is not working just fine. It appears to be working fine. It appears that we have political oversight of unelected bureaucrats inside the intelligence agencies, and we have judicial oversight of them. However, the political oversight's really lacking and the judicial oversight's not transparent. And so two phenomena are simultaneously occurring. The FISA Court being too secret and no check from our elected representatives, right, our agents. We're the principals here, we're the people. Our agents have no way to go after the court when the court goes off the rails, and so our trusted agents can't really be trusted by us. And so there's a major lack of democratic accountability. Democratic accountability is lacking already oftentimes in matters that the judiciary engages in, but at least we have the opportunity when we don't like a judicial opinion to go change a law. Right? We don't have that opportunity when the judicial opinions occur in secret, and even the elected representatives themselves who know something about the law going off the rails can't publicly win support and try and win people over to their side to try and change those laws. And so one feature of the problem is FISC transparency and secrecy, but I think it goes to a much larger issue in our separation of powers debate.
So I think now that we've set out our areas of agreement, maybe we can move on to what I think of as the two really hard questions that arise from the conclusion that the FISC is too secret. If you agree that the FISC is too secret, then there are at least two, I think, pretty hard questions to answer. The first is, what should be secret and what shouldn't be? And I largely agree with Greg that a very helpful way of thinking about that line is the one that was suggested by Senator Wyden, which is that operations should be kept secret, but the law shouldn't. I think in practice it may turn out not to be so easy to always know when something constitutes secret law and when it actually constitutes an operational detail. It may be that the devil is in the details in that question. But one way of thinking of it, I suppose, that avoids framing it as a question of secret law is to ask the question of whether the proposed conduct of the government would fundamentally reshape the relationship between the government and the citizenry in a way that you wouldn't then expect or tolerate to be handled in secret. In other words, the question is too important to be left to secret handling without some type of democratic oversight and participation. And framing the question that way, I don't think actually would subject most of what the FISC does to the type of transparency that I think is sorely needed right now. I think it turns out that there are relatively few substantial transformations of surveillance law or any other type of secret law in a way that require democratic check-in. For the first 25 years of the FISC's existence, that wasn't really the case, perhaps with one exception in the 90s where the FISC answered the question of whether FISA authorizes physical searches. The court said no. That decision was made public, and then Congress then responded and authorized physical searches. But I think those questions are generally few and far between, the ones that reshape the relationship of the intelligence agencies both to the court and to the public. But when those questions do arise, I think they're terribly important. And we're now in an area or at an age where we're going to see, at least for the next maybe 10 or 15 years, more of those questions arising on a yearly basis than we saw for the first quarter century of the FISC's existence. So there will be a number of those kind of important questions to answer as the FISC addresses new technology and new modes of surveillance. So the second, I think, hard question that has to be answered, or has to be at least addressed by those who push for greater transparency when it comes to the operations of the FISC, and also more broadly to the operations of the intelligence agencies, is who gets to decide. And this was very much the subject of the conversation of last night's panel. I hope you guys were there. I found it very enlightening and entertaining. And that, the question of who gets to decide is a very important one, particularly in a democracy where some people argue that it is really just a political question, that the line between secrecy and transparency is one that we should just trust the political branches to decide. And I couldn't disagree with that suggestion more. There are some questions of government operation that I think are too important to leave to the political branches alone. And I think the fact, I think Snowden demonstrated that in an extraordinary way, which is to say that the key insight of the Snowden revelations, I don't think was that there were particular operations going on that many people would be troubled by, although I think that is a very important revelation of the Snowden revelations. I think the key insight was that the systems of checks and balances that we have trusted for the last 35 years, since 1978, have largely broken down, which is to say that the incentives are not properly aligned to require Congress or the intelligence agencies to take seriously or seriously enough their obligation to keep the public informed about the sea changes in surveillance law that have happened over the last 10 years. So having said that, that doesn't necessarily answer the question of who gets to decide. All that suggests is that while some people may be uncomfortable with a single individual getting to decide, I am as uncomfortable with the executive alone getting to decide what is secret and what is not secret in a democracy. And I don't know what the right answer is in terms of establishing the proper mechanism for transparency to come about. On last night's panel, one suggestion was made that we'll never get rid of whistleblowers, and so we should just live with the fact of them. And I think that's probably right. I can't imagine a system that I would be comfortable with anyway that got rid of whistleblowers entirely, because I can't imagine how it would properly account for the need for whistleblowing sometimes to happen. And so I think a solution might be to look at the incentives of the NSA as perhaps solving two problems. I think if the NSA focuses on reducing the gap in public knowledge, or between public knowledge of government authority and government authority itself, that will go a long way toward reducing the incentives of someone like Edward Snowden to do what he did. Had the NSA exposed the 215 program in its early days, as the Director of National Intelligence, James Clapper, says the NSA should have done, I think it would have been very unlikely that Snowden would have done what he did, at least on the scale that he did. Had the Department of Justice defended the merits of the FISA Amendments Act in court, rather than argue that our clients lacked standing to challenge the constitutionality of that act, I think it would have been unlikely that Snowden would have done what he did. So I think there's a way within the system to reduce the incentives for individuals to take it upon themselves to decide this question, while at the same time informing the public in a meaningful way, one that actually accomplishes the goal of transparency that Greg and I think both share.
I will initially push back just on your faith in how Snowden would have done things differently had the system of laws that you and I both think would be appropriate and procedures, if those were in place, that Snowden would have done something differently. I'm actually not persuaded on that, because when you look at the vast bulk of what Snowden revealed, two things are problematic: the details about errors or intentional abuses in the 702 program and the 215 program, and everything else that's come out as a story has largely been a story about legitimate national security capabilities against legitimate foreign intelligence targets. And so unless there's some new thing coming out, which, if you're wondering when the new leaks are going to come out, I can tell you specifically the last week of March through the middle of April is when you're going to start seeing more stories, because Glenn Greenwald's book comes out in the middle of April. And if you know anything about book publishing, you leak parts of things in advance of your book so you can start ginning up sales. And if you actually don't think that that's what's happening, let's just watch and email me when the book comes out in April and tell me why I was wrong. And I'll send you all the links to all the stories that are going to sort of lead up to that. But when you look at all the leaks that have thus far come out, most don't have a lot to do with civil liberties. They have a lot to do with the capabilities of the NSA. And Snowden's concern was not that, in his own words, not that there were necessarily huge abuses going on then, but he was fearful of some Orwellian future. Right? That was his words about why he did what he did. And then also, I mean, assuming that everybody who's a supporter of his seems to think he's some like super genius. So let's just accept he's a super genius that can read 2,000 pages a day, right? He's that smart. If he had a year to read all the documents he stole, he'd still only be through about 700,000 of them, and he stole more than 1 million documents. And so the idea that he was motivated, and I know your boss, Anthony, sort of has met with him and thinks that Snowden is really motivated by all these ideological sort of things. I'm not convinced that he was that much of a sophisticated operator at the time. I think that some of that's after the fact justifications. I do agree, though, that if you don't make inside government a clear path for whistleblowers or disgruntled employees to have an outlet mechanism where they say, I'm concerned by this thing that I'm doing, is it lawful, what's going on, that you do invite this type of these types of leaks. And also if there's a perception that it seems like that the separation of power system has broken down, you also invite these types of leaks. And so there is a critique that I can level against ourselves here. During the Bush administration, many individuals in government and many national security conservatives have this view that the best thing to do is to move first as the executive on your own, and then only when you're challenged go seek support from Congress. For those of you who are hoping someday that Republicans will take back the White House and you find yourself in government and you start to have that like thoughtful moment where move first with executive power, then bring Congress on board if you have to, just punch yourself in the face. I mean, for a decade now, it's proven, at least a decade, more than a decade since 9/11, it's proven to be the absolute worst way to move forward on national security policy. It's controversial. You have less legitimacy when you do so. Anthony Romero, Alex's boss, was on a panel, a Federal Society panel, and he actually agreed with the idea that had the 215 program been publicly debated in Congress, after the September 11th attacks, or even, I would say even a couple years after the September 11th attacks, the program would be passed. It would have been enacted into law. We would have had a public debate about it. Just Alex and his colleagues would have been opposed to it because they're pretty reliable on that front. But for the most part, it would be enacted. And how do I know that? Because President Bush had a terrorist surveillance program that collected more than the 702 program does with less safeguards on it. And when it broke in the newspaper, what did President Bush do? He went out to the Rose Garden and gave a speech along the lines of like, yeah, we're doing it, and if you're a terrorist, we want to know what you're saying and who you're emailing. We want to know the content of the communication, and I'm going to keep doing it so long as I'm president. And that was like the end of the speech, and he walked away. And what did Congress do? Faced with that outrage, that bold, in-your-face sort of move by the president, revealing exactly what he's going to do, the Congress mostly rolled over and enacted exactly what the program was, with some modifications later on in 2007, dialing back some of the Protect America Act provisions. And so that to me suggests that the democratic dialogue about even some of the capabilities is not harmful to national security when had in a level of abstraction. What is harmful are allowing some idiot system administrator to make the determinations on his own about what should be revealed and what should not be revealed. Or Glenn Greenwald and his colleagues in the media. Greenwald, after his partner was picked up in an airport in London, went and tweeted, in light of the government's actions against my partner, I have a lot more documents that I'm willing to reveal, and I'm going to be far more aggressive now. Is that the person who should be making the determination about what types of things should be revealed and what should not? And so there needs to be some sort of relief valve on this. And then, I have one sort of point that I want to make to push back against it's not Alex's point, but some individuals we've heard on panels saying, like, does the enemy not know that we listen to them? This is not a big deal. If you've ever said that to yourself, think carefully about what you're saying. Of course the enemy knows that we listen to their telephone calls, right? But that's not what specifically has been revealed. That's the 215 program. But what's been revealed in the paper is actually far more detailed information about capabilities. So let me make an analogy to the CIA. We all know that the CIA has covert operatives in Pakistan. Duh, they know that, right? I'm not revealing any secret information. But what these leaks coming out the way that they've come out in the various newspapers, all thanks to Snowden, have revealed is not that, the analogy would be not that the CIA operatives are somewhere in Pakistan. Instead, they're specifically in this town in Pakistan. If you're wondering how to find them, they're in the FedEx vans with the green lettering. That's what's been revealed. And I'll just give you the example. The New York Times revealed a story that said the NSA has the capability of listening in on computers before they even start up, and also has been computers that are not on the internet. How? By implanting a device on a USB drive that draws energy from that, takes information off of the hard drive and other parts of the computer, and transmits that information out so that other individuals can pick it up, getting the information that's on the computer that's not connected to the internet. That's basically saying CIA guys are in the FedEx vans with the green lettering. Because now you go from wondering about all the computer problems to looking just at that one part of the computer. And our enemies are going dark. There's actually been an actual cost to national security from leaks. And so if you think that secrecy is the paramount consideration, which I really felt that way as a national security conservative to start with, you have to also recognize that there's an operational cost to secrecy when the only relief valve is some 30-year-old idiot system administrator with questionable knowledge about national security law and policy and questionable motives. And so we need a better system of governance just to protect operational security and national security secrets, and that's just a bonus on top of the democratic accountability points.
So now we're in the midst of the debate about what should be secret and what shouldn't be secret. But before getting to a couple of points, Greg, I just want to push back a little bit on what you said. Your claims of harm and your claims about the number of documents that Snowden took. I think it's worth taking with a grain of salt what the officials who misled us for years are now claiming behind closed doors through anonymous leaks to the press are the costs of the leaks. And if you look at some of those, for example, you see that there is a classified apparently there's a classified report suggesting that Snowden may have had access to 1.7 million documents, but if you follow the debate closely, it'll come as no surprise to you to know that no one actually knows what he took. I would be shocked if it were anywhere near that number, and yet that's the kind of rumor campaign that is started to bubble up within the administration. The same kind of goes for these claims of harm relating to the capabilities of the NSA. Apparently behind closed doors, Clapper is a little bit less worried about the leaks. He says that oftentimes claims of harm from disclosures don't actually bear out, and you don't have to look any further than Daniel Ellsberg to realize that's the case. Daniel Ellsberg, who leaked the Pentagon Papers, was called the greatest threat to, the most dangerous man in America. But now I think we know through the judgment of history that his leaks strengthened our democracy and did not weaken it.
Let me push back a little, Alex. My claim that harm to national security has flowed from this is not from leaks or anything other than government officials, when I was at the NSA, specifically telling me that there are dozens of people that we were once listening to who we are now no longer listening to.
I find that very surprising. I'll say for this reason, which is that Clapper himself has apparently said behind closed doors that even if one avenue to surveilling someone closes down, our enemies make mistakes, and the NSA is an extraordinarily capable agency. It might be that it becomes harder to collect everyone's communications in bulk when certain avenues of surveillance shut down. But security, it turns out, is very, very difficult, and the NSA is one of the best at getting around it. And so when they target their operations at particular individuals, you won't be surprised to hear that they're extraordinarily effective, as they should be. So I'm not surprised, Greg, that you have officials with a vested interest in, going after Snowden, telling you that there is dramatic harm. I haven't seen it in the actual.
Well, let's say that I'm a foreign target, a foreign intelligence target, and I all along thought having my computer not connected to the internet was a way to avoid surveillance, and then I find out that. Then I find out that there's a way through implanting a device on a USB drive that I can be listened to. is it at least possible that that person is going to check their computer, right? I mean, does it place a chilling effect on their operation? I know you like chilling effects, right? And so chilling effects are the types of things that you can't really put a finger on, right? And the harms to national security are also sort of like chilling effects, where you can't really definitively put a finger on it unless they're willing to come forward and say, you know, arms trafficker A that we were listening to, we're now no longer listening to, which nobody in government is going to be able to say because now you just told A, like, keep it up, man, you're doing a good job. But do you agree that if you're being monitored, you change your practices? Right?
I think if the chill is that our enemies no longer use technology to facilitate their attacks, then I think we've won. I think that's great. I think it turns out it's probably very difficult to be an effective terrorist if you don't use technology to your benefit. Then it turns out you hole yourself up in a compound in a country without obvious access to your your lieutenants for years, and you're not a functional part of the organization.
But to go back to your question, who should decide that?
That's the question.
Shouldn't the individuals who spend their entire career making the trade-off balance between, should we let the enemy terrorists know that we are surveilling them, thus forcing them to rely on couriers instead of technology? Should we let them know that so that they stop using their phones, or should we continue to monitor their operations electronically? Someone in government made a decision, a person whose job it is to make this decision, made a decision that it's better to make sure that the enemy doesn't know that we're listening to them than to scare them into dropping their cell phones. Right? And this is where I'm going to come back to agreeing with you. And so the problem is that determination made by trained professionals was undercut by the leaks. I mean, the leaks may have a benefit to a public dialogue, but that benefit has substantial costs, and I just don't buy the claim by those who think that transparency was great, that there are no costs to leaks. If I gave you the list of all the operatives in Pakistan, I think you would agree that that has a cost. So how is it not a cost if I gave you a list of all of our technological capabilities in the same theater of operations?
No, I agree with you that there are certain things that should remain secret, and I agree with you that those in government whose job it is to keep this information secret have access to a significant amount of information about why these things should remain secret. And they may very well be expert at making the determinations of harm that would flow from disclosure. What they are not expert at is answering the democratic question about what information needs to be made public to keep the public meaningfully informed about government activity. And so while you're uncomfortable with having an individual within the NSA decide what the line should be, I'm uncomfortable with having the executive alone decide. And that's the crux of the question. If both of those propositions are true, that it should be neither Chelsea Manning nor Edward Snowden, but also not just the executive, then who? And I think that's a very difficult question, and one that I think can be addressed, at least in part, through looking at the NSA's structural incentives. And I think the NSA has a very strong incentive now to rebuild trust with the public, and I think they should take that opportunity to narrow, to the extent that they can, the gap in public understanding about what they actually do. And I think doing that would go a long way toward eliminating the incentive for someone like Edward Snowden to do what he did. Now, you may not agree that his motives were pure, but the fact of the matter is that these types of leaks, just as a functional matter, don't happen very often. It isn't the case that every single day at the NSA someone walks off with a vast trove of information. And I think that's because most people who work for the intelligence agencies do their jobs in good faith and don't have an incentive to report things, most of which are likely not illegal or don't raise these kinds of questions. But when a gap develops over time, when you notice that for years senators have tried to inform the public about something, but they haven't been successful in convincing the executive to agree with them, that the public needs to know about 215, or when you see over the course of a decade that the government has responded to every lawsuit attempting to challenge national security policy, not by defending the programs on their merits, but by seeking to have them kicked out on all sorts of jurisdictional grounds, I think you might reasonably become a little bit distrustful of the balance that's been drawn by your elected officials. And you might think that it's up to you or no one else. And there's a way, I think, of preventing that incentive from arising. And, again, that's my only suggestion.
On that point, let me ask you to both address the question of what specific legal reforms you believe would help address the problems that you have identified. And if you might specifically comment on the idea of a public advocate in the FISA Court, and the idea that there should be a rule of lenity that is applied so that any ambiguity in the surveillance authorities that would be interpreted in favor of not having authority, in favor of privacy. So with that, Greg?
Okay. So with regard to the public advocate, I don't think that we should be, no offense to my friend Alex, I don't think we should be giving Alex a higher security clearance than he already had. You have a secret, right? No, nothing. Okay, so I don't think we should give him one at all for the purpose for the purpose of litigating before the Foreign Intelligence Surveillance Court. But that doesn't mean that I'm opposed to the public advocate. I actually sort of had this idea about the public advocate that I'm thinking of a fighting inspector general, where in the Inspector General's office, you want your Inspector General to know as much as possible about the ongoings in your organization to find violations of law and regulations. And I would put a civil liberties officer under that Inspector General and the compliance officer under that. And then that office would also have an internal, they're the opposing team inside the NSA. Their lines of command don't go to the director of the NSA, but should go external to the organization. And every time the government goes before the FISC, that someone from the advocate office has an opportunity to be there. And I think that would allow. Here's the thing that corrects. In a different context, the FBI. So the FBI was engaged in certain surveillance practices regarding national security letters that were deemed inappropriate, and they decided on their own. So there was an OLC opinion that basically rewrote authorized what the FBI was doing in contravention of what the FISC wanted. And I think that type of example where you might be able to get a court to give you a legal justification for something that you're doing is less likely to happen when you have the Inspector General who wrote the report saying this thing is wrong, standing there in the room with the court saying this is inappropriate, this is why this violated the law. And so I'd have it be an internal person. With regard to the rule of lenity, this is Oren Kerr's argument, which is that ambiguity in surveillance authorities should be interpreted narrowly. So basically a rule that tells the FISC when you're looking at statutory ambiguities, you have to construe them against surveillance and against an expansive reading. And the idea is that by doing that, the notice would then go back to the intelligence committees and Congress, and they would have an opportunity to say, wow, the FISC smacked this down, we're going to need to expand this. And there's some history for that. FISA Amendments Act of 2007, the whole debate about it was prompted by the fact that the FISC had allowed the government to engage in certain surveillance activities, and then another judge came onto the FISC and said, no, you're not allowed to engage in these activities, and the NSA and the intel community came to the intelligence committees and said, we need to change this law to authorize us to continue to collect these activities because we're taking tons of people off of dealing with these counterterrorism matters and instead having them deal with matters before the FISC. And so when the court does smack you down, there's the opportunity to have at least some dialogue. And so I think Professor Kerr's recommendation on a rule of lenity is one that I would be very supportive of, especially because it then publicly signals to us, the electorate, this is how the court is reading with a thumb on the scale against expanding surveillance authorities. And I think that's a useful development.
So I will largely agree with Greg, but I'll maybe frame things a bit differently. The two questions that I ask myself when I think about reform of secrecy are really, first, are we ensuring that the extent of authority and possible abuses of authority are known throughout government? And second, are we ensuring that at least for the things that should be public, that they are public, that there's public buy-in for what's going on? And I think the two proposals that Justice Kennedy threw out maybe each go to one or the other. I'll say, though, why I think those are the two questions. Most people, I think, when they talk about traditional whistleblowing, think about the whistleblower who, within government, makes sure that at least everyone within their chain of command, or maybe in the chain of command of a different branch of government, knows what's going on, so that there is at least full buy-in within the government on what's going on, so that no one can then later say, well, I didn't know that was going on, that happened on someone else's watch, not on my watch. If I knew about it, I would have stopped it. I think that's what a lot of people think about when they think about traditional whistleblowing. I think there's a much more important protection that needs to be put in place to make sure that there's a release valve for information to the public, that it's not always enough to trust just the three branches of government with information to ensure meaningful accountability, that sometimes the public needs to be brought in. So the public advocate idea, I think, would go some way toward addressing the first of those concerns. It would ensure that there's adversarial presentation in front of the FISC, which I think is very, very important. Let me say just for a second why I think that's important, just to give you an anecdote. When the 215 program started in 2006, as I said earlier, there was no legal opinion authorizing the program. And that's probably in part because there was an opinion from a few years before that had authorized an internet metadata program under a different statute, under FISA's pen register and trap and trace provisions. And so probably what happened is the FISC thought to itself, this program is fairly similar to that one. It deals with telephone metadata, not internet metadata, so it's probably unnecessary for us to issue a different opinion. The problem is that the program was founded on a very different statutory basis, on Section 215 rather than the pen register and trap and trace provisions. And an interesting fact about 215 is that when it was enacted in 2001, Congress also enacted a provision called the Stored Communications Act that prohibited the government from collecting phone records in particular, except pursuant to a short list of exceptions. And noticeably absent from that list of exceptions was Section 215 of the Patriot Act. And so you would think that that would be at least one statutory question that the FISC would address in deciding whether to import the logic of the internet metadata program into the telephone program, but it didn't. Not because I think the FISC was mischievous and decided not to address this issue, but because no one raised it to the FISC. The government didn't until 2 years later, in 2008, when the government came to the FISC and said, by the way, there's another statute that on its face makes this entire program illegal. So you might want to consider whether the program is in fact illegal. You won't be surprised to hear that 2 years after the program had been authorized and reauthorized numerous times, the FISC answered that question in a relatively short opinion by saying, there is this conflict, but we think 215 trumps. I think that there's very much an open question as to whether that's true. But whether you think that it's true or not, you should be troubled by the fact that the program operated for 2 years in apparent defiance of another explicit statutory command from Congress. So that's why it's important to make sure the FISC has adversarial presentation, because the government doesn't always have an interest in presenting the other side in a persuasive way, and it's not always easy as a judge to guess at what the other side is going to say. So there's a role for a public advocate. I worry, though, that it will take some pressure off of addressing the deeper concern of mine, which is that there be enough public buy-in to at least the transformational shifts in government surveillance authorities. I think a rule of lenity may go some way toward addressing that problem. It would make sure that there's not enough of not too big a gap between what the statute says and what the government is authorized to do. But I think there needs to be still a bigger shift in the way that secrecy is thought of. So one of the things that I think is extraordinarily important that be made public, and Greg, maybe you agree with me on this, are the so-called minimization procedures. These are the procedures that the government uses in deciding how to deal with U.S. person information when that information comes into its possession in the course of foreign intelligence surveillance. And it turns out that there's actually quite a lot of it. That although the NSA's mission is primarily to gather foreign intelligence, it sweeps up, as a matter of course and as a matter of intent, an extraordinary amount of U.S. person information. In fact, when they were defending the FISA Amendments Act of 2008, in 2008, they said that the U.S. side of international communications are among the most important information that the NSA gets. And that's perfectly rational. You want to know when a foreign threat becomes domestic. But the real question is, should the NSA get that information about U.S. persons under the same standard it applies to target foreigners abroad. And that's a hard question of constitutional law. It's a very, very important question given the way that our communications infrastructure works. It turns out that you might be texting a friend across state boundaries, and your text actually, if it goes over a data connection as opposed to SMS, transits international boundaries.
Okay, Greg, if you want to address this question, and then we'll move to our closing statements.
So, just so you don't have the wrong impression, I don't think Alex was trying to leave you with the wrong impression. What we're talking about is the incidental collection of U.S. person information. So the intentional targeting of the content of U.S. persons' communications without going through traditional FISA-type procedures would be a violation of FISA. But by virtue of targeting a non-U.S. person located abroad, as Alex mentions, when that person when the other end of the communication is inside the U.S., you have to do something with those communications. And so, as a matter of course, indeed, there is a substantial incidental collection of U.S. person information. And so what the NSA has done is has lots of bureaucratic procedures known as minimization procedures to deal with the collection of this information. Sometimes, like in the FISA Amendments Act, you get statutory protections, and the senators say, we're just not comfortable with all of this being determined by internal procedures. I think that's the most preferable approach to me, is statutory minimization procedures, and then the supplemental procedures. I think there should be transparency on the supplemental procedures. There is a notional operational cost associated with that, but in every one of these types of decisions, anyone who says there's no such thing as a balance between liberty and security is just trying to make everybody in the audience happy. It's a lie. Like every time you make a decision in favor of liberty, there's a slight security cost, and every time you make a security sort of favoring decision, there is a liberty cost. And so there would be a cost to security of revealing the minimization procedures. It helps the enemy figure out, I mean, not that they don't already know it, but get a U.S. person and get a U.S. phone and get a U.S. phone number. Those are the indicators we now know from the minimization procedures. So now you know if you're a smart terrorist, you get a burner phone with a U.S. number, and you get a google.com account, not a google.pk account. And so if they didn't already know that, now they're smart enough to know that. But I think that's a cost worth paying to have some transparency on the minimization procedures.
All right. If you'd like, we will now move to the concluding statements that each of you will give before we open it up for questions. Alex.
So I'll be very brief just because I've spoken a lot and I'm more interested in hearing everyone else's questions than me talk a few more minutes. But I think what has been revealed over the last year, I think, are really three crucial things. And they're things that I think we want to ensure going forward are the types of information that can get out in whatever system of oversight we have for the intelligence agencies in the future. First, I think the Snowden revelations have revealed that there's been a failure in oversight, that the balance that we struck in the 1970s of allowing the NSA extraordinary capabilities and imposing oversight, but keeping that oversight secret, has largely failed because that system of oversight hasn't ensured that the public is brought in when it needs to be brought in to ratify certain decisions or to object to certain decisions. The second is that we now live in a world in which pervasive surveillance is possible. And so while Greg is right that some of the revelations from Snowden don't necessarily concern the collection of U.S. person information, they go generally to the revelation that virtually everything that we do leaves a digital trail and can and will be collected unless there's regulation of that intelligence apparatus. And that's critically important to understanding what the balance is that we draw in the future. If you think 215 applies the way the government does, then Randy Barnett is absolutely correct that the government could use it to collect all sorts of information, and that the legal underpinnings of that theory, namely Smith v. Maryland, would really devastate privacy in the digital age. And finally, the Snowden revelations have revealed that even when the NSA engages in the collection of foreign intelligence information, it collects an extraordinary amount of information about U.S. persons, incidentally, as Greg says, but in some cases by design. And the minimization procedures in place, which were secret up until last year, provided very little protection for large categories of Americans' information. Information could be kept for very long periods of time, even though it's U.S. person information. And it's the NSA collecting it, which is supposed to be focused on foreign intelligence threats. So that's the sort of information that I think any reform of the FISC needs to ensure can be public and is made public to allow the conversation that we're having now to take place in the future.
I think the most, I'll try and do these in the order in which I think the reforms could be implemented. The idea that the NSA keeps secret all of the bureaucratic procedures that have to occur prior to someone being able to access data just boggles my mind. So just take the 215 database. Before you can query the 215 database, this is all of your phone records, there has to be reasonable suspicion that the seed number is somehow connected to a terrorist organization. And so, like, that fact alone should probably have, like, once all this came out, should have been on like a website. And then, oh, by the way, who can actually make the determination that there's reasonable suspicion to believe the person's connected to a terrorist group, and the 33 individuals above that person who have to approve it, and the fact that all of those things are audited by an internal compliance team and by the general counsel, and audited by the director of national intelligence and the inspector general for the intelligence community, and also DOJ and DOJ's lawyers. And oh, by the way, it's the DOJ lawyers and the NSA lawyers have something of an adversarial relationship, because the DOJ lawyers have to make sure that they're not perjuring themselves before the FISC. It's not the NSA's lawyers that go before the FISC. And so when you look at this robust internal bureaucratic accountability, which I know some of you hear that and you think not accountable at all, but if you've ever worked in a job, you know you follow the rules, you show up to work on time, or you lose your job and you get disciplined, and people have been disciplined in the inside the NSA, losing their security clearances, losing months of pay, losing their jobs. And so that type of thing, the fact that that's not transparent, I think is the type of thing that if I were in government, I would immediately turn that around. I would go farther than the rule of lenity, and I would, if I were in Congress, I would make all FISC opinions presumptively disclosed. And so unless the judge makes a determination that certain things should be redacted, or that the opinion in toto should not be published. And then any decision to redact or not publish should be automatically appealed to the en banc FISA Court of Review to double check all of the decisions that judge did. And I think that when a judge knows that the opinion is going to be read, it's going to be circulated, it's going to be read by appellate judges as well, I think it changes the way the opinion is written, and also that would add some additional levels of oversight. I think presumptive review by the FISA Court of Review for significant legal interpretations should also be a requirement, and my trigger for significant legal interpretations would be a government application that says, we believe this provision applies to this in the following way, and then seems to make an argument that departs from the statutory text. I think that there should be an automatic trigger for the FISA Court of Review to review that. And again, I have transparency procedures worked in. I think two things then finally on the political oversight that could change things. This is a political non-starter, but I wish it were the case. Give the Intel committees actual budget authority over the people that they supervise. So if you're on the House or Senate Intelligence Committee, you have the ability to conduct oversight, but you have no ability to make anybody do anything because you can't control their budget. Their budget's controlled by someone on the Armed Services Appropriations Committee. And so for a long time, many people have realized that really hamstrings you as a member of Congress. I'd shorten the sunset provision timelines on these types of bills so that we have consistent renewals and public debate on a more regular basis, 1 year, 2 year basis. I'm fine with having lots of fights about it. It gives me lots of law review articles to write. And then finally, I think that members of Congress need to remember that, like, when Wyden ran into this sort of buzzsaw on the 215 stuff, not being able to reveal details of the program because of some stupid internal Senate committee rule, he could have taken to the floor of the Senate and talked about programs. In fact, some people argue could even talk about classified information on the floor of the Senate, and your revelations would be protected by the speech and debate clause. And so it's not that members of Congress don't have the ability to reveal information, it's that they don't have the political will oftentimes to pick those types of fights. And so that's a sort of a broad package about transparency and accountability that I think could help to reform our practices. And now I think we're going to questions, right?
We are now going to questions. So we've got 15 minutes for those, and I will repeat what the other moderators have said. Questions, please. And if it begins with, would you believe that, that's probably not a question. Although in the form of the question, not the kind of question we're looking for. So if you'll keep your questions as focused as possible. Yes.
Hi, Matt Petzinger, University of Maryland. I just had a question kind of bouncing off of the final comment, specifically the various layers of kind of bureaucratic checks that have to be signed off on in order for a query of a database to proceed. Is there an incentive in place within that system? I mean, I look at Clapper lying to Congress and not being punished. If all of the decision makers, the decisions that they made and the grounds for which they decided that there is a reasonable cause to run the query are secret at every step of the way, and when publicly a falsehood about those particular these kinds of things goes unpunished, where does the incentive come in for someone to actually say no? I mean, as long as there is any line that can be drawn, no matter how tenuous, where's the pushback that says, well, it's a little too tenuous here? Is there anything that prevents something that in any but the most absolute there is no cause cases, is there any incentive for a refusal?
Yeah, so the internal procedures are a bit unlike other internal government procedures where you've got a rule book and you follow it, or you might have some sort of discipline in your performance evaluation. The procedures largely come from orders from the FISC. And so the FISC is in the business of every 90 days the government has to go back on the 215 program and say, these are the procedures we still have in place, these are the number of queries that we did, this was the basis of reasonable suspicion on which we decided to do this. And so someone at DOJ is making the representation before the court, standing before a judge, knowing that the judge is going to ask the tough questions. And so then that DOJ attorney, reporting to the Attorney General, has their own incentive to make sure that their representations are true, which sort of puts them in an adversarial relationship with those who have an incentive to do the collection on the NSA side, right? So there have been instances where individuals have failed to adequately prove reasonable suspicion or whatnot, and the court has smacked them down. Was it 2009 where the court was, because of misrepresentations by the government, the court said, we are going to check every one of your queries of the database to ensure there's reasonable suspicion. Now that is one of the reforms that President Obama says he's going to put in place. He's just going to take the reasonable suspicion determination off the hands of the individuals inside government and shift that over to the FISC for supervision. And I imagine you could have that in other programs, that type of more direct judicial supervision in other programs. That might be a worthwhile reform, I guess.
I think key to that reform, though, too, would be ensuring that the FISC has maybe better means at its disposal of understanding the technology. So, for the first 3 years of the operation of the 215 program, this is the problem that Greg was talking about. Thousands of queries of the database were happening every year that shouldn't have happened, that hadn't gone through the appropriate mechanism. And that was perhaps in part because of a technical misunderstanding by the FISC. Under the FISA Amendments Act, it turned out, according to Judge Bates, that tens of thousands of purely domestic communications were being pulled into the NSA's collection, and the FISC accused the Department of Justice of engaging in substantial misrepresentations to the FISC. But it may have also been the case that there was a technical misunderstanding of the FISC of what was going on. So I think it's important to also, if we're going to double down on that mechanism, which I think we shouldn't in its current form, but even in some kind of reformed version of it, we should make sure that there's sufficient technical expertise on the court. One way is through making sure that they can actually ask technologists to explain what's going on with clearance, people whose job it is. And another, and my preferable way of doing it, would be to make at least the broader questions of law subject to public adversarial testing, so that there's someone with a real incentive on the other side to present the full picture.
Right, thank you. We'll move to this side. Next question.
Hi, I'm Peter Margulies. I teach at Roger Williams Law School. I'm delighted that some of my students are here as well. This is a question mainly for Alex, so I'm delighted to have Greg weigh in too. It's a question about the Stored Communications Act. So, Alex, you said that the Stored Communications Act precludes the collection of call records under 215. I know the ACLU makes that argument in its brief to the Second Circuit in the Clapper case as well. But there's a question I have about that, which is that if you look at the legislative history of 215, you have a number of members of Congress, including Representative Lundgren, who say the point of this provision is to try to stop terrorist plots before they are completed. The example Representative Lundgren gives is supposing a known terrorist is having dinner in a restaurant with a couple of other folks. Shouldn't you be able to get the credit card receipts for that dinner to ascertain something about the nature of those plans, even if you don't know who those other folks having dinner with the terrorist are? So if you say that about credit card receipts, what sense does it make to not have the same standard for phone records?
Well, there are a couple of responses, I suppose. One is that the NSA already had that authority under FISA's pen, register, and trap and trace provisions. There are a number of other ways in which the government can acquire phone records. They can issue NSLs, which don't require judicial review, but are a little bit narrower in their scope. NSLs can only be issued for a certain class of investigation, where Section 215 can be issued for broader classes of investigations. And so,
but you don't need identifiers to get an NSL. Is that right?
You don't. Sorry, you said you don't.
You don't need identifier. You don't need seed accounts, as Greg mentioned, to get an NSL, national security letter. You can get that the same way you get a subpoena.
Yeah, that's right. You need something that you're going to actually serve on the person who's going to give you the record. But there are a couple of reasons to think why Congress may have wanted to route requests for phone records to the existing authorities rather than create a new broad one. But even if you disagree, and I accept that there is reasonable minds can disagree about whether the Stored Communications Act makes this program illegal, I at least was troubled that the first time that question was considered was in 2008, 2 years after the program had been in operation. The people who like to point to 15 judges approving the program don't often point out that the court wasn't presented with the arguments it should have been considering in that secret review.
Thanks very much.
All right. Next question on this side.
You had talked about the speech and debate clause and Wyden there. As far as I'm aware, at least, had he actually gone to the floor and just talking about the classified information, there would have been some type of ethics complaint brought up against him for doing so. Should we perhaps have better rules in the bodies of the legislature so that they can bring these things to the floor in a closed session and advocate for the public release, or some type of legislative way of deciding that these things that are classified shouldn't be classified?
Yeah, it's interesting. So the speech and debate clause could inoculate him from punishment for criminally disclosing the information, but would it protect him against a internal ethics complaint? It would essentially be the same complaint that would come for violating the Senate Rule 9.3 that I mentioned. And I would have to imagine that the superior controls the subordinate here, especially a provision that speaks directly to what members of Congress are allowed to do has to trump the internal rules that the members of Congress came up with. Again, though, this is like a pipe dream on my part, because members of Congress don't want to look like they're embroiled in a scandal, so they don't have the political incentives to do very much on this. They also don't have political incentives to look like they're opposed to security practices at all, and we see this in the targeted killing context, and we see it in surveillance too, right? The last thing you want is you go forth and you reveal this 215 program. The program gets shut down because everybody's opposed to it. You're the guy who championed the cause of shutting down the 215 program. Then a terrorist attack happens and someone says, man, that information would have been in the database if we had only been able to query it. That doesn't win you any votes anywhere, maybe in the Bay Area, but it doesn't win you any votes anywhere else, right?
At the ACLU,
right. We got one or two from Alex and his friends.
All right. Next question on this side.
I just would like to ask your opinion on the growing use of private contractors to fulfill the previous public functions of the NSA and your proposed framework with dealing those in the future.
Do you want to go in there, Greg, with your framework? I mean, I don't have any principled objection to the government kind of expanding who can work with the government through these arrangements. My concern at the end of the day will always be the same one, which is whether there is sufficient accountability built into those arrangements to prevent there from being unaccountable action by government. And I would primarily think about unaccountable, unlawful action by the agency as a whole. I think others might rightfully focus more on unaccountable leaks or that type of concern. But that's the framework that I would use to analyze any specific kind of contractual relationship. I don't have a principled objection to it.
Yeah, I mean, and so on the accountability point, I would think that the security clearance procedures should be identical for those individuals and whatnot. But to me, I actually would like there to be some sort of financial penalty. Like Booz Allen should have suffered for Snowden, not just the NSA. And in fact, they should have suffered monetarily. There should be some sort of structure in place that hurts their bottom line, and hurts their bottom line in a way because I'm at a Federal Society conference and I'm a conservative. I believe that people respond to incentives. I actually believe the free market responds to financial incentives. And so if you had penalties associated, financial penalties that far outweigh the person's salary or whatever their cost for failure to check that the employees that you're putting in place are not security risks, I think that would actually enhance security, right? Put your money where your mouth is, Booz Allen, and make sure that you're sending us people who are not security risks. And that might mean that Booz Allen does a lot more checks on people and does their own internal polygraphs and other things, such that we have a second level of accountability with people whose money is on the line. So I think you could actually improve security by having contractors, not in our current status, but with some smart reforms.
All right. I see no one standing for...
I have one final comment.
One final comment.
So I want to leave you with a thought that didn't come up on our panel, but I hope it comes up later. So we have a targeted killing panel later on, drones and whatnot. And you'll frequently hear people who talk about drones say that there's no way that you can know who it is that you're targeting based just on signals intelligence and whatnot. And I'm hoping one of you asks those people to reconcile that claim, oftentimes made by ACLU people, with the same claims made by ACLU people that metadata reveals every single piece of detail about my life, and you can know where I go, and you can know my doctor records, and you can know this, and you can know that. So if we can know all of that as a civil liberties concern domestically, think how much more we know about people abroad when we're not protecting them as U.S. persons. And I'm sort of tweaking Alex here because I think
you're garbling our argument a little bit, Greg. But we can have that debate on the side. There's no doubt you can identify people. There's a question of whether we should be comfortable killing people who we haven't identified.
Don't go to the moral question. I'm just anyway.
All right, that's for later. Again, I want to thank you both for your very thoughtful remarks. I think this was a debate, but it was relaxed, and I am very pleased to have had the opportunity to moderate, and I'm very pleased to let you out 2 minutes early for lunch. Enjoy.